Okay. I'm going to start over since no one could hear me. Thank you guys for putting up with my little technological glitch. It's ironic because I actually did practice this. Okay, this is Elizabeth Potts Weinstein, and you are listening to the 6 common legal mistakes made by small business owners and how to fix them. And today I am speaking to you guys with my attorney hat on. For some of you guys, I know I can see the attendee list. So you guys I've known for a long time, and I've taught a lot of classes in the past on a lot of other different kinds of issues, including legal and financial things too. But it's fun to be able to do this again because I haven't taught a class in a while, and also to be here in my attorney guise. For those of you who don't know, I am an attorney licensed here in California and before the United States Patent and Trademark Office. I also do have clients in other states as well as California. And I'm excited to be bringing this stuff to you guys again. It's funny since I've already said all these things once about 2 minutes ago when you couldn't hear me. I'm having it's hard for me to remember what I've said now that you guys can hear me. Anyway, many of you have already figured out that you can ask questions in the little webinar screen. Those questions go just to me. Other people can't see them. And I will answer questions as we go if it's appropriate to share it with everyone. I won't say your name to protect your anonymity. But if I don't get to your question, then I'll try to answer them at the end. I think I'll be able to see them all and be able to go back. So it looks like I'm checking that I haven't had anyone say this. I can't hear you again. Okay. So let's go ahead and get started now that I got through my technical glitch. All right. So because I am a lawyer, I, of course, have to give you disclosures before I can teach you anything. So the first disclosure I want you to be aware of is that I'm going to be talking about laws of the United States. Now, I know that some of you may not be in the United States, which is fine to a certain extent because the same issues come up. Okay, so if you're in Canada, if you're in Europe, wherever you happen to be, Australia, probably not listening to this live, but wherever you are, the same issues will come up, but the law may be very different. In some places, the law is the opposite. So I just want you to be aware of that. And as I said, I'm licensed practicing in California, but I do have clients in other states. So I do talk about the law of more than one state. The second disclosure is that this webinar is not legal advice. So obviously, if you have a real legal issue, you do need to either do the research yourself or contact your own attorney. This is just a great place for you to get started, to know what issues you need to research or you need to discuss with an attorney. Because I find that that's the biggest problem for people who are trying to handle their own legal stuff is that they don't even know what they don't know. So that's hopefully what I can bring to you guys today. So let's go ahead and actually get started, okay? Okay, so the first thing I'm going to be talking with you guys about today is about, this is a pet peeve of mine. There's this myth. I think it's not just among small business owners. I also think it's among lawyers, and especially among lawyers who are selling stuff on the internet about what you need to do as small business owners, that incorporating as a corporation or as an LLC, forming some kind of business entity is enough to keep you safe. And when I say safe, what I'm talking about is, let's say something goes wrong and that you're not able to pay off a debt, your business isn't able to pay off a debt, or you have a contract that goes bad, or you have an employee who thinks they've been sexually harassed, or you have someone come to meet you for coffee and they slip and fall on the ice on the front steps of your house and they're there to meet you for business. Something goes wrong. And what we want, the idea is that if your business is in trouble, we want that to be separate from you. So if someone wants to sue, they're suing your business and not you personally. So they're not going to be able to get at your personal checking account in your house, etc. So you want that business to be separate. And the danger is that a lot of people think, oh, well, I incorporated. I'm a corporation or I'm a LLC. And interesting, they use those words, which is inherent problem, which I'll talk about in a second. But they formed this entity and they think that that is the end. And so I'm here to make you guys aware that it's just really the first step of what you need to do. The first thing is that you need business liability insurance. Now, what business liability insurance is, it's you have probably homeowners insurance that have a liability part of it, and your automobile insurance has a liability part. If your business gets sued, we don't want it to go under from getting sued. If that client slips and falls on the ice in front of your office, even if your office is your house and your business is theoretically liable for their broken leg or whatever, if that business gets sued, we want someone else to pay for that lawsuit and have to pay for that problem. And so that's what business liability insurance covers, just like you have insurance for your car and insurance for your house. So I see so often that people don't have this. Sometimes they have malpractice insurance or professional liability insurance, as a lawyer or as a health professional. That doesn't cover this. That covers you being sued by a client who thinks you're incompetent. Hopefully you're actually not, but who sues you anyway. This is talking about other kinds of lawsuits. In business liability insurance, I'm kind of using that as an umbrella of a whole bunch of different kinds of business insurance you need, but really you would be talking to someone, an insurance agent who does this kind of insurance. So this is actually one of those things that even if you're a sole proprietor, you need this. And this is a way that some people, and I actually have clients that I recommend this to, sometimes staying a sole proprietor is actually okay if you have enough business liability insurance. I'm not going to say it's always okay because there's times where it's not, but this can be a way to be a sole proprietor and still have yourself be protected. The next thing you need to be aware of is honoring the corporate formalities, which sounds very fancy and lawyer-ish. And that's, in a way, it's because it is. It's actually not complicated, but the idea is that if you have a corporation, if you have an LLC, that's the separate entity. It's a separate person in the definition of person in the legal sense. You need to honor that, treat it with honor. That business is its own thing. And so you don't commingle stuff. You don't treat it in a squishy kind of way that's an extension of you. Now, sometimes this can be stuff like minutes and meetings. Like I said, it's not just minutes and meetings because, for those of you who have a corporation, less true than LLCs, but for corporations, you have to have board meetings and all this stuff, which is, I have a corporation and it's silly because I'm having a board meeting with myself. It's really, I have to do all kinds of bizarre legal fictions like that. So there are silly things like that. Less of that is true for an LLC, but that's not just it. It's also treating that, honoring the fact that that's a separate entity from you. So it has a separate checking account, a separate PayPal account. It has its own Amex card or whatever you use. You sign contracts on behalf of the business. If you're going to do something for the business, if you're going to loan money to the business, if the business is going to open a checking account, whatever it is, the business has to make that decision and not you. And there's paperwork for that. You don't want to pay yourself by just randomly taking money out of the business's checking account to go grocery shopping. You need to pay yourself some kind of salary or draw or however. There's a lot of different ways you can do it to make sense for your business, especially if you have fluctuating cash flow. But you need to not treat it as just your personal checking account. And so all those things is about honoring the fact that that's separate from you, because that will make it much more likely that a theoretical court, if you're involved in a lawsuit, will also respect that you kept it separate. And for those of you who are one-person businesses, this is incredibly important because it's really easy for a one-person business to get in trouble and have the court say it was just an extension of you and that you're personally liable for its debts and obligations. So that is my spiel about corporations, LLCs. That's just the first step, and there's a whole bunch of other things that you need to do. both insurance and the corporate formalities. Next thing I wanted to talk about is in the same category of business entities is the most dangerous form of business. This is also another pet peeve of mine. Now, it's not sole proprietors. People think that it is, and there's a lot of like talk out there that it is. That if you're a one-person business, that being a sole proprietor is the worst thing you can do. Not necessarily. If you have no employees, if you're in a particular kind of business that's not a huge liability risk, like you don't do landscaping or some physical thing where like people can get injured really easily. There's some kinds of businesses that wouldn't make sense for. You're just one person, you're doing everything yourself, you have adequate business liability insurance. Sometimes it makes sense to be a sole proprietor, especially for the short term. But there is one kind of business I would say that you should never be. And that is an accidental partnership. This happens all the time and is the most dangerous thing that you could possibly do in business. So first, let me tell you why it's dangerous. So let me give you a hypothetical. Let's say you and I decide to do this project together. And we actually believe it's a business. So, we're thinking that this is this project and we're going to make money on it. We're engaged in this business for profit, hopefully. And let's say it's this landscaping business. Let's go back to that. And we need to buy equipment. And so you, without talking to me, on behalf of the partnership, go out and spend $30,000 on equipment. You don't even ask me at all. Maybe I even told you I thought it was a bad idea. I am now personally liable for that $30,000 of equipment, of the debt that you used to buy that equipment for the partnership. Personally liable, not just liable on behalf of the partnership. Also, let's say you do a bunch of really stupid stuff. Like you're out there, doing sexual harassment on the employees, and maybe you electrocute somebody in the house you were working on burns down because you did some terrible electrical thing, whatever. Like horrible things happen. I'm personally liable for that now because we just have an old-fashioned partnership. This comes up a lot unfortunately, with people who are friends. They're in some kind of relationship of sometimes a really long time, and they think that they can just have a gentleman's agreement and shake hands, and they don't even have a contract, much less an LLC or something like that. This also comes up accidentally, and I say that where people think that they're entering into a joint venture, and it's actually a partnership. So there's all kinds of liability attaching to that. And there's also like tax problem. You need to file taxes, a partnership tax. So a lot of things can accidentally happen. Now, it's true. You could have joint ventures with people and have it not be a partnership. Okay. But you need to be precise about how you're phrasing things and how you structure the payments out, how you're splitting the money. I actually, now that I've been working on this with people, realized there was a couple of things I did a few years ago that I called joint ventures, and we did them as joint ventures, and I don't think they actually were. Now that I'm like looking at going, ooh, it wasn't a huge amount of money and obviously no one got sued, so it's all good. But yeah, bad idea. So my thought I want you guys to take away with for here is really to, whenever you're going to go into any sort of project or business or anything with another human being or another business, right? You really have to evaluate, is this a partnership? Is this a joint venture? And you need to have documentation. And you may even form an entity like an LLC or something to handle all the liability and issues there. So that's my takeaway for that. Okay. Looking over the questions. One person said they can't hear me. Can anyone else hear me? It's so odd because I can't. It's because it always says that people can. So it's very strange. Um, okay. I'm going to keep going. If this ends up not working over and over again, then I will not use GoToWebinar. I actually tested multiple systems, and this was the one that worked the best. So we shall see. All right, I'm going to keep going. So what's missing from your contracts? Now I'm going to have a couple of things that I'm going to talk about, which is under the world of contract law. And just to let you know, like 90% of what I do with my clients really is contract law. I think for small businesses, especially one-person businesses, this is uh, the thing where legal issues come up the most. And this is also the place where you're most likely to have problems. And ironically, it's the place where most small business owners don't get any help. You may hire a lawyer to file your trademark application, but you're using a contract that you got from the International Association of whatchamacallit, and you're using that with your clients, and no lawyer's ever seen it. And so that's one of the reasons I wanted to talk to you guys a lot about contracts today. So what's missing from your contract? So here I'm going to go into some like real legally kind of things. Looking over at my other computers to make sure that's working. There are two clauses that I see missing from contracts all the time that are actually very simple and easy to include, and that really will save you a ton of headache later. When I say clause, I mean like just a little paragraph. That's what a clause is. I don't. So sometimes it's hard as a lawyer to know. Do non-lawyers actually know what I'm talking about? So let me look over. Okay. So a bunch of people can hear. So I'm saying, if you can't hear me, let me know. That's totally idiotic. Okay. The recording will be available, so if the audio does cut out later for anyone, you'll get it then. So these two clauses that can be easily included in contracts will save you tons of money and time if things go badly. That's what these are about. And then you're missing a lot, I think, because a non-lawyer, and even lawyers who have never done litigation, don't think about how important these are. So the first one is called choice of forum. Sounds probably legal-y. But the word forum probably have a connotation of like location for that. Forum is a place, right? So choice of forum is if we have a problem with this contract, we have to fight about it. Where are we going to do that physically? Where is this going to be fought at? This is hugely important for those of you who are doing business with people in other locations. So let's say you are in Washington State and I am here in California, and we have a contract to do whatever, and we have a dispute, and we get to the point where we're going to sue each other. I'd much rather litigate that thing here in California than in Washington State. I don't want to schlepp up there, have to find lawyers up there, deal with the logistics of that. I want to have that lawsuit here. Adds a huge amount of certainty to me and convenience, and reduces my expenses. Also, even for you in Washington State, it can be helpful to have the choice of forum in there as California or whatever, because it gives you certainty. Here's what can happen. So let's say we get into this debate and we decide to file lawsuits. You file a lawsuit in Washington State, and the same day I file a lawsuit here in California. Now, our lawsuits aren't even going to be about this contract. They're going to be about where should the lawsuit be. So we're going to have this big fight and have to pay lawyers thousands of dollars to fight about where should we have this gosh darn lawsuit. It's totally not worth it for anyone. And there's no reason to have this problem. So I'm going to pick where we're going to fight about this lawsuit. And what all the clause says is, like my contracts say, if we're going to have a lawsuit about this, it's going to be, you have to file it in Santa Clara County, which is where I'm located. So they're pretty simple. The next kind of clause that should always be in there is called choice of law. This is one of those things that I think didn't realize before I became a lawyer. Is that just because you have a lawsuit in California or Washington State or wherever doesn't mean that the law of that state is what the court is going to use for the lawsuit. You could have a court in California doing a lawsuit that is going to apply the law of New York to that contract if there's a choice of law clause that says New York. So these are two separate things that you pick. A lot of times they're going to pick the same. I always put California in mine. Almost always, probably. But sometimes you actually pick them different, and there's a reason. So here's where this can come up. The reason choice of law isn't just because we don't want to have to fight about it later, even though that's true. It's because the law of different states can actually be different. Radically different. So one example, let's go back to California and Washington State. Let's say you're in Washington State and you decide to hire a virtual assistant, and your VA is here in California. So you draft a contract, and the contract has all kinds of things saying that she's an independent contractor, and also says that she cannot compete with you. You don't want her to take any of your trade secrets, and she's not allowed to compete with you because you don't want her to take all the knowledge from you and then start her own business to compete with you. So she can't compete with you for 1 year. Okay. Well, if you don't have a choice of law clause, you're going to have a problem. You may have a problem anyway, but if you don't have a choice of law clause, you're going to have a problem. Because let's say later on, you guys have a falling out, you fire her, and then the lawsuits happen. Let's say there's a huge amount of money, because a lot of times lawsuits aren't going to come up. But she files a lawsuit here in California. You file a lawsuit in Washington State. If California law applies, that clause that says that she can't compete with you is illegal, because those clauses are illegal in California. If Washington State law applies, then it's fine. If it has enough restrictions, like it said 1 year, it can't be forever, it's probably fine. So there are clauses like that in one state is illegal and in another state is legal. Non-compete is a very classic example, but there's also, whether or not someone is an independent contractor. In certain states, like in Colorado, there's magic words that has to go in that contract. It's not true in other states. So what law applies is incredibly important to know. Is your contract even going to do what you intend it to do? So both of these, I enjoy some of the questions. Both of these clauses are very simple, and I'm sure you could be able to find form clauses if you want to include these in your contracts. These are not complicated things. They're like one sentence. So let's go to the next thing that's actually related to what I was talking about. Who decides if your virtual assistant or any independent contractor you hire is an independent contractor or an employee? I wrote a blog post about this a couple months ago. It's becoming more and more of a hot issue. So virtual assistants, for those of you who don't have one or haven't used that, is something that's been around for not a gigantic amount of time. You may be experiencing degraded audio quality. Okay. Oh, goodness gracious. All right. So anyway, I just got a message from the GoToWebinar saying, you're experiencing degraded quality in your audio. The scary message is off now, so hopefully it's working fine. So virtual assistants are people who perform various services. The classic example is someone like a secretary, but this person is virtual. They could be located anywhere in the world. They're doing this all remotely for you, even answering your phone, handling your email. It's kind of a classic example. But there's virtual assistants who do all kinds of work for people. And people love hiring virtual assistants because they can hire them and not have to hire an employee. They can pay this person a certain fixed amount per month or hourly, and they don't have to deal with payroll taxes and all the junk you have to deal with when you have an employee. And they can also just hire them for, 10 hours a month or some tiny amount, which can work for great for people. Problem is it's not that simple. Who decides if your VA is an independent contractor or employee, which is very important because if they're an employee, you got a whole list of laws you got to comply with, payroll tax things, all kinds of stuff. It's not you who decides if your VA is an independent contractor or employee. It's not you. It's not your virtual assistant. Just having a contract that says that your VA is an independent contractor is not enough. It's a myth that it is. I've talked about this before and actually had VAs get mad at me. They're like, I've been doing this for 10 years and I've always had this contract. And, I'm like, well, okay, but it's still not binding on any state that you have this contract. Whether or not your VA is an independent contractor or an employee is based on state law. Most likely, it's the state your virtual assistant is located in. Now, there's also federal laws involved too, but it seems like that's not where people are getting in trouble as much in reality. Let me give you the hypothetical, the story of how people get in trouble. So what happens is you hire a virtual assistant. Let's say you're in some other state. You hire a virtual assistant in California. It goes badly. You fire this person. And then this virtual assistant goes and applies for unemployment insurance, like unemployment coverage, right? Once they're checked. And says, yeah, I was an employee of this person. State of California goes after you and says, we want you to pay us for paying this person unemployment. And you say, well, no, she was an independent contractor. Here's the thing. In California, it is presumed that anybody who's doing work for you is an employee, and you have to prove that they're not. And the contract isn't proof. It's just a tiny little piece. You got to prove how the relationship actually worked. It's a whole gigantic list of stuff. Now, it's not true in every state. In Colorado, for example, there's magic words that can go on that contract, and there kind of are magic words, that shift that presumption. And so then as soon as you put those magic words in your contract, they have to I think they have to even be bold and everything. Then the state of California says, okay, now we're going to assume that the contract is valid. And then the virtual assistant can come back and say, try to prove that they were an employee. So my point is that when you're hiring an independent contractor, especially for someone who's going to be working for you on an ongoing basis. So we're not talking about, it's less likely to come up for someone who's doing a project for you. They're just designing a logo for you or something. If someone's going to be working for you for months, if not years, you need to look at the law of where they're located and see what you need to do with the Department of Labor, whatever they call it in that state, and find out what are the rules, especially about payroll taxes. So it's going to be with one part of that person's state. It's going to be the agency that deals with unemployment, and then the agency that deals with workers' comp. You need to find out what are their rules. It could be in statutes or regulations, different places. Most places have good websites now. Thank the Lord. It must have been really hard to do this stuff before these websites existed. But you could go on and find out what are the rules, because sometimes it's magic words that need to go in the contract, and then sometimes you need to change the way in which you deal with this person. For instance, charging by the hour sometimes can get you in trouble. Okay, so who decides if your VA is an independent contractor or employee? You need to look at state law. Okay, this is something that I actually kind of referred to. Is it okay to copy contracts, terms of service, forms from other people? Now, I'm actually going to talk about the copyright problem. That technically people have a copyright over what they wrote. That's another issue beyond the scope of this. But I mean, is it okay to copy contracts from a legal perspective in the sense of, is it a good idea? So a lot of people, you get this client contract for coaching from the International Association of what's it called, or you look at terms of service that are used on other people's websites, or you get forms that you downloaded from some database or from some book, like the CD-ROM that comes in the back of the book. Can you use that stuff? So the thing is that I use those things too. Okay? Lawyers use that stuff. It's not that it's a bad idea inherently. I don't ever draft a contract completely from scratch. That would be a terrible idea. I'd be reinventing the wheel. There's no reason to do that. However, the missing link is that I don't ever use anybody else's contract or even little pieces of their contract without evaluating it and having it go through a couple of filters. So the first thing is if you're going to look at someone else's contract form, stuff you get off their website, whatever, and you want to use that legal language, you need to look at what state is this person in? What country is this person in? Obviously, that could be radically different. Because if they're in another state, they may have different requirements. So, for example, and actually, even what industry are they in? For example, I'll see, like I was talking earlier about the Colorado thing with the virtual assistants or any independent contractor. Colorado has magic words that need to go in that virtual assistant agreement. So if you're just using the general virtual assistant agreement that comes from whatever association that you're in, you need to add in the language from your own state that makes it work in your state. And this is true about a whole lot of this is true about a whole lot of other industries. If you're a financial planner and you want to have an arbitration clause in your contract, there are specific words for, I think it's for anyone who's certain kinds of financial planners and investment advisors. I think it's RIAs, the people who have to have them, that have to go in there for arbitration clauses. So a lot of different places have magic words that need to be used, or where the law is fundamentally different. And so you need to be aware of that. This is another example, and this is not an area in which I cover in the kind of work that I do for my clients. Let's say you're going to draft a will. You want to make sure it's like the will is for your own state, because every state has different rules. So there's a lot of laws like that that are very specific. What year is this thing from? If this is some internet thing and it's from 2001, I mean, that's 1,000 years ago in internet law, right? So you want to find out what year is this thing from, because the law may have changed since then. There may be different requirements. And you also want to look at, does this thing make sense? I was looking at a client's contract they gave me that was like a form that they got from one of those, international associations or whatever's. And this contract was horribly long and at a tiny point font, which just is a red flag. And I was reading through it going, so much of this is completely unnecessary. And also, it doesn't make sense as far as resonating with this person's practice. If you're, for example, a life coach and you're doing this, spiritual life coaching, you don't want this contract to be total legalese that no one can understand and it's like sounds horrible. You know what I mean? Like there's no reason that this stuff can't be in resonance with what you're doing. And you also want to make sure that all the stuff that you're included actually applies. If you're going to get terms of service that you're putting on your website for everyone who comes to your website, and it has all this language about membership sites or buying products off this website, and you don't have a membership site and no one can buy products off your website, like there's no reason for that to be on there. Just creating a mess. So don't forget to use common sense. And lawyers can forget to do this too. So, and actually lawyers forget to do this a lot. There is a common sense part of it to make your contracts make sense. Because the thing is, the point of a contract isn't to protect you in case of litigation. That's actually not the number one point. The number one point of a contract is to make this thing that you're doing work. I think of my contracts with my clients as being a great education for them, for seeing, here's all the things I'm going to do, here's all the things you're going to do. Some of the things I put in there aren't about us suing each, like they have nothing, I'm not even thinking that they're going to be litigation, things. They're about my client being aware of, here's what I expect and here's what I plan to do, so you know what to expect, so we can make this relationship work. And that's true even if the contract you're doing has nothing to do with business. So don't forget to use your brain. Okay, the last topic I wanted to talk to you guys about is another area that I deal with a lot with my clients, which is about trademarks and copyrights. And what is the point? Is the heading. First, I want to talk a little bit about trademarks versus copyrights and what's the difference, because I think people are really confused about this sometimes. So I'm going to start with copyrights. What's a copyright? So look at the word copyright. It has the word right in it. And it is very much a right. It actually comes from the Constitution. So a copyright is if you create a creative, artistic work and memorialize it in tangible form. This could be writing something, it could be electronic, okay? It doesn't have to be physical. Electronic counts as physical, tangible. It could be an ebook, it could be a painting, it could be taking a picture, it could be recording something like this. Anything that has been put into tangible form that's a creation, that's creative. In the United States, you automatically have a copyright in it. The idea is we're rewarding you for creating it. And you have it automatically, kabam, the second you do it. Now, if you need to sue somebody, you will have to register that copyright in the Copyright Office of the United States. But in the US, you don't have to do the registration to have the copyright. You have it the second you make that, put that creation into tangible physical form. Electronic is part of physical. A trademark, however, is very, very different. So you can just look at the word. It does not have right in it. It's not called a trade right. It's called a trademark. Trademarks are not a constitutional right. It doesn't come from that. People think of it as a right. They think, oh, well, I'm a business owner and I came up with this tagline. I came up with this logo and I've been using it in conjunction with a product or a service. And as such, I have a right over this. I have a property right. No, that's not actually what you have. Because trademarks are there not to reward you for coming up with this thing that you have. Usually it's the name of a product or service, it's a logo or symbol or a tagline, that kind of thing. A trademark is to protect consumers. Because here's what we as like a society, what we want is that consumers go to buy a Gucci bag. We want them to be able to go, if it says Gucci on it, that it's a Gucci bag. That it says we want them to be confident of that. Because if they went and bought something that said Gucci and it's not a Gucci bag, it's a counterfeit, we want to protect them from that fraud. That's what trademark law is about. It's about protecting consumers from being tricked, from the likelihood of confusion. And the reason I explain that is because it's really important for how things come out later. Because when you're deciding what you want to trademark, it's important to understand the big picture of how this is going to fit into your overall plan. So let me give you an example of I'm going to put up both my bullet points of trademark versus copyrights and how it actually comes out very different. So let's talk about copyrights first. So you wrote this ebook and it's like your gift to the world. It is, this is an amazing thing that you wrote. You automatically have a copyright in it in the United States the second you typed it into the computer. You, however, could choose to give it away. You could choose that you could choose to just license it to everyone in the world, that they don't have to pay you any money. They can copy it, print it out, do whatever the heck they want with it. And there are people who have done this, like Zen Habits. They've done a lot. There's been people who have done this so they can disseminate that ebook to everyone in the world, either as a marketing thing or because they just want to give it away. Like it's their message they want to give to the world. I've actually done that with some stuff too. And the thing is, though, even if you choose to give away that ebook to the whole world, you still have a copyright. You've just chosen to license it for free. But you still have the copyright. Totally different than trademark. So I ask in the bullet points, I say, you need to think about, is this aligned with your purpose? And enforcement is everything. Because in trademark law, if you're going to trademark something, you need to think about, what is the big picture? Because are you going to actually enforce this trademark down the line? What is the plan for how you're going to do this? So my example is live your truth, which is, for those of you who have known me for a while, living your truth. I have a tattoo that says live your truth. This has been my tagline, for lack of a better word, for a very, very long time. It's even still on my website, even as I'm doing legal things. I did not trademark live your truth. And I did not trademark it on purpose. Even though a lot of people said, oh, you should trademark this. A lot of lawyers said I should trademark it. There were some legal reasons I didn't, because it actually would have been difficult to trademark. But that's beyond the scope of this. The point here. The reason I didn't trademark Live Your Truth was because I knew I was never going to sue people for using those words. I didn't want to have to enforce that trademark. I didn't want to have to write every gosh darn blogger who uses the word live your truth and tell them they have to either license it from me or stop reusing those words. That's totally like out of the point of live your truth for me. This was my gift to the world in the sense of I wanted it to go out to a gazillion people and have them use it. And it's actually been really, one of the really neat things is, when you would Google the words live your truth in 2009, when I first started talking about it, no one talked about it. But I tapped, and I don't think that I was the first person to talk about it by any means. But now, if you Google that, it's all over. People use live your truth all the time. So if I would have gotten a trademark on it, I would have to send cease and desist letters to all those people. And if I didn't, I would lose the right to be able to enforce that trademark. Just like aspirin is no longer a trademark, just like Pilates is no longer a trademark. If no one's enforcing it, it can become genericized. It can become generic. So when you're thinking about, do you want to trademark something? I want you to think about, would you be willing to police this? And you may or may not. Now, I'm not saying you would have to like sue everybody. You could have people, there are situations where you could have people pay for relatively inexpensive licenses and cite back to you. I mean, there's creative things you could do, but you would need to maintain control over all of the uses of it. Otherwise, you lose it. It's a very important thing to think about. And I think people will regularly file for to get a trademark on things because it's like a checklist of what businesses do. You incorporate, you get a checking account, you get business cards, website, you get a trademark. And it's a lot more goes into it than that. It needs to be part of your overall strategy and plan for what you're going to do with it. So that's my all the things I was planning to talk to you guys about today. It actually went faster than I thought because I probably talked really fast. I'm going to go back and look at the questions in a second. But before I go do that, I'm not going to go into a big like spiel about, what I do, whatever thing, as I think that since I'm an attorney, it's, hard selling legal stuff is just gross. So I'm not doing any of that kind of stuff. But just to kind of let you know what I do, I specialize really in small business owners who are either taking a hobby business or something that's really just at the idea stage and they're turning it into a real business. I'm not going to tell you that doing legal stuff, getting your legal ducks in a row is like going to magically make it so your business makes money. Because it's not magic. There's people who say it is, but it's not. However, it does make it so you can keep more of the money that you make. And that's really what we're talking about. Let's keep what we're making. So we don't, have a $1 million business that goes bankrupt, which has happened very many times. What I specifically do is I'm outside general counsel, primarily for one-person businesses. You can't hire me just for one project. I take people on an annual retainer. It's flat fee annual retainer, so I don't charge by the hour or any of that stuff because I hate that stuff. So if anyone's interested, you can just go ahead and send me an email and we can chat about if it makes sense for you. And you also go to my website and I have a ton of information about how it works. So you can get more information there and also a whole bunch of articles and things like that. And everyone who's on this webinars probably on my list now, and because that's probably how you came through this, so you'll be getting all the future blog posts and things like that that I write. So let me go ahead and look at the questions. I wish they had it make it's this horrible tiny scroll. Okay, so here's one question that was just asked: how does copyright law apply to the internet? For example, a photo I took and posted in my business blog, do others the right to use it, even referencing me or link to me? No. Very short answer. So when you have something that you created, you took a picture, you put it on the internet, it's still yours. People don't think this, but it is. It's still yours. It's still your right. I suggest that on your website you say, copyright 2013, you have your name or the name of your business, all rights reserved. Like, you want to put some language in there, not because you have to, but because it lets people know. But it's still yours, and you haven't licensed it to everyone for them to use. However, people still do. They somehow think that if it's on the internet, it's free. So sometimes you may need to send nasty grams to people to get them to take it down. If you do want to use pictures on your website that you don't take, and you want to use other people's pictures, if you go to Flickr, you can actually search for pictures that people have licensed under Creative Commons, which is like form licenses, for other people to use. And you just have to link back to them and stuff like that. Sometimes you can't use them for commercial use, but sometimes you can. Depends on what people specifically did. But that's a great place to get photos. So copywriting music is automatic. Yeah, so in the US, and I say that because this is not true in other countries. In the US, you automatically have a copyright. Registering it with the Copyright Office is good for, number one, you have to do it before you can sue anybody. And number two, it proves that it's yours and that what the date was that you created it. So if you think that someone may later on, this is something that's really valuable and to you, and is likely that someone could say it's theirs, it may be helpful for you to have this government document saying, well, on January 30th, 2013, I have this document and it's stamped by the Copyright Office and it said that this is mine. That helps. So I think it really only makes sense for things that are really important and likely to get copied and taken. Obviously, you're not going to copyright send every blog post to the Copyright Office to register, because that would just be onerous. You can actually copyright groups of things if you're gonna do stuff like that. How do you know if a joint venture is actually a partnership? That I need to write a blog post on this. The short answer is that if you're engaged in a business for profit, where you're sharing profit and loss, that's when you cross the line. So I think one way to think about it is when you're doing a joint venture, you're gonna do this project with somebody. Are you sharing the profit and loss? You both have the risk of loss. You're splitting the profits down the middle. That's the thing that's going to be, you have to be really careful about. I'm not saying there's not ways you can deal with it to keep it be a joint venture, but that's where people tend to cross the line. So for example, something that's not a partnership is when you have an affiliate program. You're not sharing profit and loss. They're just getting a commission. You know what I mean? That's one way to keep it. And I've actually done that in the past, where what we intended it to be a joint venture, but one person was the seller and the other person got a 50% commission. You know what I mean? So really only one person had the risk of loss. For electronic stuff, sometimes there's not a true risk of loss. It's not there's not inventory or something. You know what I mean? So let me go back and look at some things. What about a VA in the Philippines? So I don't know about Philippines law specifically. Obviously, I don't. One thing you think about when you have a virtual assistant or anybody working for you in another country is where, kind of brainstorm yourself, where could this run into problems? Who would care? What could theoretically happen? So, you have a VA in the Philippines. I don't think the United States is going to care that you're not paying payroll taxes on this person. You know what I mean? Like where or Canada or wherever you happen to be you're located, right? Um, so it is about the law of the Philippines, you know, whether or not this person is an independent contractor or an employee and what laws apply. I have no idea what that is. Um, and so that's something to take into consideration. If it's, of course, a country that you never go to, you're less likely to have it be a horrible problem for you. um, if someone did sue you there and get a judgment in a lawsuit there, they're going to have to try to enforce it against you in your own country, which is an extravaganza. And so, from a financial standpoint, it's probably not going to be worth it at the level that we're talking about. But technically, it is the law of that person's country that's going to apply. Most of the time, that's why people, when they hire like virtual assistants in another country, they're not hiring individuals. They hire like a company that has, 100 VAs or whatever that work there. That helps shield you from some of these problems. That's true even in the United States. I'm going back to see if there's anything. So a typical JV with internet marketer is a risky thing for an info product. Yeah, it's. I actually am going to, I think, write a blog post about this eventually. It's on my list because I think going into some of these details is going to be something I need to explain in written form. But yeah, you really do need to be careful with when your typical joint venture, where we're going to put on an event together, or we're going to do a teleclass together, and we're going to split everything. It'd be really easy to have that be an accidental partnership. I would worry most about it if you're doing it like a physical event. Like, I mean, like people show up in person. There's a lot more liability, both financial liability and, liability of someone breaking their leg or whatever. Someone asked a question earlier, do these concepts apply to freelancing? So one thing is that as a freelancer, you have a business. I mean, you may not think of it that way exactly, but it is. So this all the same rules for any kind of business apply, whichever side you're on. I'm going back and see. Okay. Okay, so if anyone else has any other questions, feel free to ask them right now. Of course, you have probably gotten an email from me already, and you can go ahead and just send me an email. I hope that you were actually able to hear me most of the time and that you guys learned some good stuff on this webinar. If you want to, as I said, ask me other questions, you can shoot me an email, type it in right now, or send me a question on Facebook or on Twitter. Otherwise, I will talk to you guys next time. Thanks a lot. Bye-bye.